So, when we talk about what is Dalil Shari, then it means the Quran or Sunnah. So, the science of Fiqh, Usool Fiqh and Islamic law carries a paramount place because it is science of Adillah or proof, evidence based, and deductions of ahkam from them. Adillah Shari'ah and ahkam, that is laws or values from them. Adillah Shari'ah and the ahkam, laws or values that regulate and conduct the mukallaf are the two major themes of Usool Fiqh. What is Dalil Shari and how the mukallaf, the one who is obliged to follow, should act. Ahkam are derived from Adillah and are therefore subsidiary to the Adillah. They are based on them. I refer to a well known jurist on this subject, and he explains that Adillah Shari'ah are defined as signs of the proof of fiqh, Adillah Fiqhiyah, and the indications that they provide in regard to the ahkam of the Sharia. I am not here supposed to go in detail about jurisprudence. Class of jurisprudence, it is a class of Islamic thought and culture in which we are trying to understand what is role of jurisprudence. Therefore, do not mistake my discussion for a class where ultimately we will end up in fatwa. No, that is not the purpose. The purpose is to have just an idea how jurisprudential methodology helps in application of Quranic principles in economics, in political science, in sociology, in psychology, in biochemistry, in physics, in all areas. However, the concept of aql, taklif and Adillah Shari'ah tell us that things are to be in harmony with reason, but reason alone is not the judge. Then it tells us that whatever is given by Sharia is applicable subject to a person's capacity, receptivity. If a person does not have that capacity, for example, a child who is just 6 years old is not obliged to make prayer in congregation or individually. But if this child makes prayer in congregation and individually, perfectly okay, yet he is not mukallaf, he is not accountable. But when he crosses the age which is required for making prayer, like bulugh, bulugh may take place, maturity can take place early or later. The so called UNICEF definition which we apply globally, 18 years, is not medically, socially, physically verified. It is just a hypothetical number. In Sudan, in many parts of the world, some children are mature in the age 10 years, 11 years. What does that mean? That means that if they can make judgment, if they can understand things, if biologically they are adults, then why they have to wait for another 8 years for exercising their right? This is illogical, irrational, inhuman. Yet, because of our slavery of mind, we accept that only one who is 18 years is baligh. The point here was not what should be the limit, but point here is that unless a person has competence, cannot be accountable, and this is a principle of Sharia. Usool al-Fiqh, Adillah Shari'ah refer to 4 principles or proof of sources, that is the Quran, Sunnah, Ijma and analogy. Usually these are 4 sources which are discussed in Usool al-Fiqh, and from all these 4 we try to draw conclusions based on their very clear evidence or indication. The first 3 are categorized as mustaqil. That means that they are having a proof that is of more valid reason, while Qiyas is an asal or dalil muqayyad, subject to change, draws its authority from one or another of the 3 independent sources. Qiyas is based on the Quran or Hadith or Ijma, but not by itself independent. That is what the meaning.